So we're here to educate you about one of the programs that affects crime victims. Before we begin, we have to give our disclaimer. This presentation is not intended to give or provide specific legal advice. The information today is current as of April 23rd, 2024. And this PowerPoint may not be reproduced, distributed, copied, or cited in whole or in part without Coast to Coast Legal Aid of South Florida's written permission. For more information, please visit our website at www.coasttocoastlegalaid or call 954-736-2400. Again, this program deals with Broward County's Domestic Violence Misdemeanor Diversion Program. As both Paul and I are attorneys for victims in intimate partner crime cases, as well as representing the elderly who are also victims of crime in criminal cases, today we want to give you a victim's perspective on the program. First, what is the Misdemeanor Violence Diversion Program? Well, the diversion program is an alternative approach to resolving a misdemeanor domestic violence case. It is an alternative from the traditional path of going to trial and having a conviction or a not guilty be decided by a jury. It takes a lot of the steps out of the criminal justice system for the victim and creates a more sure path. It provides, we'll get into a little bit more of what that means later on in the program. But for now, just know that it provides accountability for the criminal conduct, but it also provides a therapeutic intervention that addresses the factors that may have led to the incident of domestic violence and why that they are in court. At the end of the program, if the defendant successfully completes their program, the guilty plea that they have to enter to start the program is vacated, and the case will be null prost or dismissed. Again, the defendant must enter a guilty plea. They must, in the program, have to complete up to 12 months of county probation. And during that time, they have to complete a 29-week batterer's intervention program, otherwise known as BIP. There may be other special conditions involved that are required of the defendant to complete the program, and they are usually dependent on the victim's wishes. Some of the special conditions that are asked for frequently are substance abuse evaluations and the defendant having to do any follow-up treatment that's been recommended, mental health evaluation, and also following up with all the recommended treatment, parenting classes, and sometimes restitution. In order to enter the program, the defendant has to waive certain rights. One of the rights that they must waive is the right to speedy trial. They can no longer force the state to go to trial within a certain period of time. They also waive the right to discovery, that they won't be receiving the evidence in the case. As they have to enter a guilty plea, once they've entered that plea and entered the program, they lose that right to later withdraw that plea. And they cannot contest whether or not the state attorney decides that they have been non-compliant. It is solely up to the state attorney's office to decide whether or not they've complied with the program or they haven't.
Hi, everyone. Once again, I'm Paul Yoon, attorney here with Coast to Coast Legal Aid of South Florida. As Ms. Weisberg mentioned, we represent victims of crime, specifically intimate partner violence. And most of our work is in the domestic violence unit in misdemeanor and felony courtrooms. As Pamela Weisberg also mentioned, we also represent senior citizens who are victims of crime. Doesn't necessarily have to be intimate partner violence or domestic violence in nature. Any senior citizen victim of crime, we can assist them as well. Now, I'm going to discuss a few things here. Ms. Weisberg kind of laid out what the program is about, some of the general provisions about it to start with, but we're not going to get into the defendant's eligibility requirements. This is key. There's a whole process to this. It takes time to get to where a lot of our clients who are victims of intimate partner violence want to get to. It takes time for a defendant to get to a resolution. Excuse me, but it all starts with the defendant's eligibility requirements. Okay. Eligible offenses. This is based on Florida Statute 74128. Assault, battery, violation of injunction. Just to kind of elaborate on that, assault is a second-degree misdemeanor. punishable by up to 6 months of probation and or up to 60 days in their county jail. Battery is a first-degree misdemeanor, as well as so is a violation of injunction. Both first-degree misdemeanors are punishable by up to a year in the county jail or up to a year of county probation. So those are the eligible offenses, very limited there. And this is a very limited program, as you'll see. Another factor as part of the defendant's eligibility requirements involve the past adult criminal history. We're going to separate adult and juvenile. The defendant must have no prior adult felony convictions or no more than 2 prior convictions for a non-violent misdemeanor crime. Before I go any further, I just want to say, this is the Broward County State Attorney Office program. It's not the judge's program. It's not pre-trial program, probations. This is the state attorneys. They put up the parameters. They set up the eligibility requirements for offenders. And this is what they came up with. Excuse me. So to continue, a prior non-violent felony conviction may be considered on a case-by-case basis. Any prior domestic violence convictions and or pending filed charges will automatically preclude consideration for the program. Excuse me, as I mentioned just a moment ago, it's a limited program. It's a unique program. It's an alternative approach to addressing the traditional prosecutorial method of a criminal case that can lead to, as Ms. Weisberg mentioned, convictions, jail time, probation, which is different from the diversion program style of probation. So that's why the state attorney set up these parameters, because it's a unique program for specific situations, specific eligible defendants, and that's why there's these specific conditions. A past juvenile criminal history is a relevant factor for the state attorney to consider. A defendant under the age of 25 who has a significant juvenile record may be disqualified and denied entry into the program. Key words here is may be disqualified. That means the state attorney, it's their program, they have the discretion. It's a case-by-case basis. They will review an offender. Okay, is this too much? What is significant? They will decide. One thing I do want to mention here, as Ms. Weisberg stated earlier, that this presentation is through a victim's perspective. And I think what cannot be lost in this kind of eligibility discussion is a victim's position. His or her voice needs to be heard. If there are eligibility requirements that are by case basis, well, then a victim should absolutely be included in the state attorney's evaluation. And that's why when we see words like may be disqualified instead of shall be disqualified, we, Pam, Ms. Weisberg and I, who represent victims of domestic violence, intimate partner violence, who are interested in this program and seeing what it's all about, how it can benefit them, how it can benefit the offender. We want them to have a voice. So oftentimes what Ms. Weisberg and I will do is try to set up a phone call with the city attorney's office so that they can hear our client and what they want to see happen. And maybe that will either sway the state attorney who's evaluating the case to offer diversion or maybe not. So that's huge in our representation and more so for the victim, our client who is involved. Now, prior diversion, what that means is this: a defendant will only be permitted to participate once in a lifetime in the domestic violence diversion program. I think Ms. Weisberg can back me up. I have never seen someone go and get into the program twice. Whether they successfully completed it or they were kicked out for non-compliance, I think I've only seen them get one shot at it. A defendant who has previously participated in the domestic violence program shall be ineligible. Keywords here, once again, shall be. There's no and if or buts. That means the state attorney, when they came up with this program, decided, you know what, if you've already been in, that's your one only chance. Because that means you are a repeat offender if you're back in that courtroom. That naturally gives way for the state attorney to say, okay, you're not eligible for this program anymore. Now, the last little bullet point here is a huge relevant factor. That's why it's all capitalized and bold. The listed victim or victims, there may be more than one, must agree to the defendant's admission to the program. Key word, obviously, must. This is where a victim of crime literally has control of a case. And we love that. Oftentimes our clients feel powerless. They feel that no one's listening to them. They have so many questions. They don't know where to go, who to talk to. When we talk to our clients and we see that an offender may be eligible and the state attorney lets us know that an offender may be eligible, we preach to our clients, this is your case now. You have the power to dictate the outcome of this case at this time with the diversion program. That's why it's very crucial for our clients to fully understand what it means for them to allow an offender to get into the program, as well as what it means for the offender him or herself. And we'll get into that here in just a moment. So once again, I got to repeat this, consent to the victim is required. The state attorney's office must receive consent, keyword again, must, from the listed victim of the crime before diversion can be offered. If a victim says no, that's it. The state attorney can't overrule it. The judge can't overrule it. And I should say this is once again the state attorney's program. It's not the judge's program. The judge has no say until one point, and we'll elaborate on that here in a little bit. But this is the state attorney's program. So if the victim says, I'm not interested in this, I don't think this is the right level of justice for me, and the victim objects, that's it. Too bad. The program cannot be offered to the offender. The victim may request additional special conditions. Now, this is under the understanding that the victim does or is interested in consenting to the program. He or she may request additional special conditions such as mental health evaluation, a substance abuse evaluation, or parenting classes. Ms. Weisberg has been doing this for a little while, and what we've seen is that there seems to be a common denominator with a lot of our domestic violence cases. And these are those common denominators, a mental health issue that has to be addressed. Substance abuse, I'll tell you what, that is a really shows its face in a lot of our cases, whether it's alcohol, recreational drugs, whatever it may be. And parenting. We are predominantly in domestic violence courtrooms. It inherently means that there's a relationship, number one. Number two, oftentimes there's kids. And that could be a cause, a rub in the home where it causes friction and some animosity. So maybe a parenting course or classes can help both sides for that matter, but more specifically for the defendant. So those are some special conditions that can be implemented should a victim consent to this program. This is very important as well. And this goes to safety of our clients, of a victim. Contact may or may not be permitted during the diversion period of supervision. So once again, the victim has the say in this. If he or she doesn't want contact with the offender, that's it. No one can say you have to. The judge said, no, Mr. or man, you have to have contact. It cannot happen. The state attorney can't allow contact if the victim doesn't want contact, and vice versa. This is once again wholly within the parameters of the victim and his or her authority. Victims may request contact, limited contact. We see this often. Like I mentioned just a moment ago, there's oftentimes kids involved. Well, they still want to try to co-parent. They have to drop off the kids, pick up the kids. There's daycare this, daycare, all kinds of things. So a victim may want some limited contact for the care and custody of the minor children. Oftentimes, we suggest something called Talking Parents. It's an application, a court-approved application that monitors the contacts between the parties, and it's strictly for the care and custody of the minor children. So it keeps the victim safe, so there's no kind of back and forth between the parties that's outside the scope of what the victim wants in terms of his or her contact with the defendant. Okay, so accountability for noncompliance. So we've talked about what the program is. We've talked about what it takes to get in there. Now what happens if an offender is in the program but is non-compliant? There's accountability, and this is key because Ms. Weisberg and I preach to our clients oftentimes in these situations, don't forget that we're in criminal court. There is a crime that occurred. So there's going to be accountability at some point should there be non-compliance. And that's very important for our clients to understand because they're still seeking some level of justice. And Ms. Weisberg will discuss that a little bit more in detail, but that's a big factor. So if a defendant fails to comply with the program's special conditions, as noted before, mental health, substance abuse, parenting courses, the contact provision, there's also, Ms. Weisberg mentioned this at the very beginning, the battered intervention program. If you can see how that is associated with this case, it's a diversion program that incorporates battered intervention sometimes, these classes. those special conditions. So if a defendant fails to comply with those conditions or fails to comply with whatever contact provision there is, but generally it's no contact. So it fails to abide by the no contact provision or is arrested for a new law offense. Any new law offense. It can be driving while license suspended, a petty theft, anything. Doesn't have to be domestic violence in nature. The defendant can be unsuccessfully terminated from the program. Once again, as Ms. Weisberg mentioned at the beginning of this presentation, it's the state attorney's discretion. They will decide. But generally speaking, I haven't seen a lot of people, if any, get a second chance should they violate these conditions, the contact provision, or especially if they pick up a new charge. I've never seen anybody allowed to stay into the program. But once again, that's with the state attorney's office. This is my second bullet point here. The determination of noncompliance is in the sole discretion of the state attorney's office. The defendant, by electing to participate in the program, waives any right to contest the state attorney office determination of noncompliance and termination. Ms. Weisberg mentioned this earlier in the presentation. They waive this right. Once they enter that guilty plea, they're saying, okay, I'm at the mercy of this program. I'm going to go in here and I waive my right to contest anything that you find is determinative of noncompliance or termination. And that's part of the deal. Unsuccessful termination of the program. Upon unsuccessful termination of the program, the defendant shall be sentenced on their earlier plea of guilty. A defendant who fails to appear for sentencing will have a capias, otherwise sometimes referred to as a warrant, issued for their arrest. That's why this guilty plea is huge. And Ms. Weisberg mentioned it earlier. It's significant to a lot of our clients that are willing to agree or consent to the defendant getting into this program, because once again, a crime occurred. Victims still are looking for accountability for the crime that occurred. And oftentimes, when they hear that the offender must enter a guilty plea, that gives them some level of closure to say, fine, it seems as though he's acknowledging, for what it's worth, that he or she, I should say, the defendant put them in this situation. And that's why this guilty plea is a huge factor in the evaluation of this case for our clients who are victims in domestic violence. But once again, once they enter the guilty plea, there's no taking it back. That's it. He or she, the defendant, will be at the mercy of the court. Now, what is the benefit to the victim? Once again, we are here. It's National Crime Victims Week. This is a presentation through the perspective of a victim. What benefits are there to the victim? There are a lot. First of all, it avoids deposition and having to testify at trial. Ms. Weisberg and I have represented hundreds and hundreds of victims of domestic violence. And we've had to advise them of a deposition. We've had to advise them of testifying potentially at trial should there be no resolution to a case. There is nothing more stressful. There's nothing that causes more anxiety to our clients than having to go through a deposition where they're going to be in a little room and the defense attorney asks questions about what happened, attacking the credibility, questioning the victim. It's a very uncomfortable situation to be in. And having to testify at trial in front of strangers and they have the case in their hands to determine whether or not the defendant is guilty or not guilty, it avoids all of that. That's a huge burden to be lifted off of our clients who are victims of domestic violence. In the same vein here, it takes some uncertainty out of the criminal justice process for the victim. Oftentimes we get clients who have no idea what the criminal justice process is all about. No clue. They've never been through it before. They may have called the police before, but they may not have gotten this far where charges have been filed and an offender is facing criminal prosecution. So the diversion program gives them power. It takes uncertainty out of the whole process of the criminal justice system and gives the victim power to control how they want to see the case be resolved. So that's a very huge benefit to our clients who are victims of domestic violence. Also, this may allow the relationship to continue with less animosity between the parties upon the conclusion of the case. Remember, we're in domestic violence courtroom. There's a relationship. There were good days too, but we're here because of a bad day or a few bad days. There's kids involved. Property, cars, jobs, all kinds of things that impact a relationship. But this program is designed to do is to take the sting out of oftentimes those issues that may create the parties to butt heads and things of that nature. Hopefully this will lower the temperature of the room, and that's what this program, a factor of this program being designed in the domestic violence courtroom. It may also assist in continuing to receive financial assistance by helping the defendant maintain employability. The criminal justice system is expensive to go through it as a defendant, whether it's through this program or whether it's through probation, it's expensive. But what this program may allow is for the defendant not to lose his or her job, because oftentimes what Ms. Weisberg and I have heard and seen is that the defendant, most of them are male, are the breadwinners. So if they're in the traditional prosecution courtroom and they're facing jail time, they lose their job, a conviction can lead to losing their job and deny employability. I mean, a domestic violence conviction in the record is a real scar there. That will only potentially cause more problems. So again, not that this program is cheap, but it will factor in the financial assistance of the victim by allowing the defendant to maintain employability. And lastly here, among others, there's other benefits to the victim, but lastly here on the slide, may get help for the defendant that they need that they would not receive without court intervention. This goes back to the special conditions. Let's say there's substance abuse issues. Well, if the victim wants, there can be that special condition. Hopefully, I always preach to my clients, you can lead a horse to the water, you can't make it drink, but at least there's an opportunity for a defendant to get help if he or she desires it. Mental health, substance abuse, parenting, anger management, that's huge. I haven't said that much, but anger management is part of the batteries intervention program, the therapeutic nature of addressing, the holistic nature of addressing those issues. So once again, these are some general benefits to a victim through this program. One other benefit I have to mention is restitution. So restitution is the repayment of financial losses incurred as a result of the criminal action alleged. Full restitution or civil lien for the full restitution amount must be paid prior to the satisfactory completion of the diversion program. Sometimes there's damage to property. A phone may be broken during a domestic violence incident. Damage to furniture. Maybe the door gets ajar and things get, the wood is broken from the handle or whatnot. Well, if there is a nexus to the crime alleged, as the slideshow states, then the defendant will be on the hook, will be ordered to pay the restitution amount back to the victim. And this is one of those special conditions. If a defendant does not abide by this special condition, he or she could face non-compliance. So this, once again, is to make a victim whole, a benefit to the victim.
So what justice is for one victim may not be justice for another. This program provides a very specific kind of justice, and it's not appropriate for every victim in every situation. There are some who just want the defendant to get help. They're going to have a continuing relationship with this person because of children or other reasons. But some others don't want to have any contact, don't really care about them getting any help. They just want them out of their lives, or they want a mark on their record of the defendant's record to warn others who may encounter them in the future. They want them to know what they're capable of. Because once a guilty plea is entered and then vacated, and the case has been the program was successfully completed, the case is dropped, and that can make some defendants eligible to have the case expunged from the record completely, erasing all marks of what happened. There are also some victims that they just want a more harsh punishment for the person who abused them. If they want to see the defendant do some jail time, this program cannot provide that for them, and in which case this program would not be appropriate for them. Some really just want the guilty plea as opposed to a no contest plea. No contest is telling the court, I'm not saying I did it, I'm not saying I didn't do it, I just think it's in my best interest to resolve the case with a plea without going to trial. But this program requires that they enter a guilty plea and take full responsibility for what happened. Depending on the victim, this may be an appropriate program or may be completely inappropriate. It depends on what they want to see for the system and what justice means to them. Another factor that needs to be considered by the victim before offering the diversion program is the immigration consequences that are not avoided by this program. Even though the guilty plea that's entered is later vacated, the immigration consequences can still be triggered. The person can still be deported for entering a plea of guilty to a domestic violence charge. Crimes that are considered domestic violence are very ripe for deportation and immigration issues for the defendant. And if the victim wants the defendant to stay in the country for whatever reason, because if there's children involved, for whatever reason, then this program again would not be appropriate for them, as it can trigger the deportation of the defendant. Also, it was mentioned briefly before, but it's worth mentioning again that this program has a huge financial cost. The Batterers Intervention Program is very expensive. If there are other special conditions, such as a substance abuse evaluation or mental health, that all has to come from the defendants. They pay at their own expense. There is not a state providing these treatments for them. They have to go out, seek it themselves, and pay for it themselves. And entering this program, as opposed to, say, going to trial and winning, or having the case dropped altogether without the program, the money that would be spent in this program could instead go to childcare, alimony, or restitution if the defendant can't afford both the program and to pay the victim back for costs incurred. Just wanted to give everyone an idea of what the program looks like on paper. This here is a contract that is signed by first the judge, the state attorney offering the program, the defendant, and the defendant's counsel if they have them. It contractually obligates them to complete the program. It says that they have to be monitored by county probation. They have to complete the Batterers Intervention Program, and they have to pick their provider and let the court know what provider will be offering them that program. There's a provision for no contact. As we stated before, no contact can also mean no harmful contact. It can mean contact only for the care and custody of the minor children. That's generally up to the victim what kind of contact would be allowed. Also, as you see, there are some places for the special provisions, the substance abuse evaluation and any recommended aftercare. Because it's such a common program, it's already put into the contract. And as stated before, it is at his or her own expense. The contract also says that they may not consume any alcohol or controlled substances without a prescription, and they cannot possess a firearm or weapon during this program as defined by Chapter 790 of the Florida statutes. Once this is signed and agreed upon, a guilty plea is entered, they are officially in the program, and there's only two ways that the case can go from there. Either a successful completion and a dismissal, or they stand by their guilty plea and are sentenced by the judge.
And one thing I just want to mention real quick in terms of the process that it may be helpful for everyone to understand is that if a victim consents to, well, if a defendant is eligible and then a victim consents to the defendant getting into the program, there's a change of plea where this form, just like Ms. Weisberg showed y'all, whatever special conditions will be implemented. And then what the court does is they set a status date about 30 days out to make sure that the defendant who agreed and signed the contract and said he would enter the program would first report to probation and enroll in programs or pretty much get started. So there's going to be a status hearing date to make sure that is the case. There's paperwork found. There's a memo that's found that says, okay, the defendant has been accepted and into the program. And then from there, what the court generally does is, I believe, it's about 8 to 10 months out, Ms. Weisberg. They'll set a date out to make sure that the defendant is continuing to be compliant. One thing that I wanted to also mention is that what will happen is that because this is done through probation and being monitored through probation, the probation officer will let the state attorney know if the defendant is non-compliant. That's where the communication is. And that's when the state attorney will then take the initiative to bring the case back into court set up for a hearing, and to address the noncompliance. So that's kind of the procedural part of it. I just want to briefly mention so that you're fully aware of generally how that moves forward once a defendant gets into the program. All right, so that's the end of our presentation. Thank you everyone who watched and who will be watching. We appreciate it. If any of you are interested in what the work that Ms. Weisberg and I do, generally in terms of victims' rights, or have any specific conditions about questions, I should say, about this presentation about the Misdemeanor Diversion Program with the Broward County State Attorney's Office, please feel free to contact us. You see our phone numbers there. For both Ms. Weisberg and I, as well as our emails. And of course, our general website for Coast to Coast Legal Aid of South Florida. You will see information there as well. And I always have to at least include this year, the other services that we provide. We are a holistic office. We try to help as many civil legal issues as we can here. Under family law, we deal with injunctions for protection, divorces, paternities, paternity cases, I should say. We also, I want to do a little shout out to our family court advocacy at the main courthouse. It's on the 4th floor. That if you are at the courthouse and you're dealing with a family law issue, we do have a little branch over there on the 4th floor that you can stop by to get some information. Some referrals are done directly from there, so take advantage of that. And we also have a couple other units here. I just want to briefly mention the Senior Elder Law Unit. As you can see, some of the services provided there, as well as the Economic Advocacy and Community Health Unit. We call that EACH. And they assist with, as you can see, some disability issues, healthcare access, and things of that nature. So if you have any questions about any of these services that we provide, please visit our website, once again, coasttocoastlegalaid.org, or contact our office. I believe our phone number, there it is, right there, 954-736-2400. Once again, thank you very much for watching our presentation. On behalf of Ms. Weisberg and I, we appreciate it. And once again, this is National Crime Victims Week, and I hope you enjoyed this. Thank you very much.